For the parties, each side will be allowed 15 minutes. For the appellant, they can reserve rebuttal time, but you need to let us know when you come up how much time you want to do for rebuttal, okay? Okay.
One question, Your Honor. Mr. Hill's going to argue part of this, and I'm going to argue part of it, because there's some things are similar, but others diverge. How do you want to handle that?
How you want to divide your time is up to you.
Okay, well, I just like stopped and let him come up there. You know what I'm saying? And I don't want to,
Well,
I haven't done this kind of thing before where two of us would argue.
okay. You're going to be arguing pretty much at the same time, you mean?
Well, no, like, I was going to do the issue that is common to both of us, and then an issue that's mine, and then he was going to do the issue that's his.
Okay. Well, as long as you're within the time span, then I'll let you do that the way you want to do it, okay? Okay. For the first case, then, the appellant,
I'm sorry.
the appellant,
Yes.
first case.
Good afternoon, Your Honors. Appreciate you taking the time for us today. My name is Tamara Hill, and I'm representing myself. And we're going to reserve 3 minutes for rebuttal.
Okay, then. And you proceed, and you just let us know when you're ready to relinquish, and he can come up, as long as it's within that time frame that you have. Okay.
Thank you
Go right
very
ahead.
much. I'll put my glasses on because I can't see. May it please the court, the fundamental issue in this appeal is whether a trial court may create and coerce enforcement of a judicial settlement agreement the parties never reached after consent was withdrawn, and then compel performance under threat of contempt. It is not about who pays the property taxes. Secondarily, and out of abundance of caution, Ms. Hill, having made no agreement to the contrary, appeals the trial court's refusal to grant her summary judgment on Mr. Boren's remaining claims. Mr. Boren argues that this court does not have jurisdiction. He is mistaken. The order drafted and signed by the trial court on April 8, 2025 is designated as a final order. Conversely, the order authored by Mr. Boren's counsel, from which he wants this court to calculate the 30-day period for notice of appeal, is not designated as a final order. In addition, all issues had not been resolved by entry of the March 20, 2025 order. Motions had been filed by all parties and were still pending, including the issue of fraudulent inducement by Mr. Boren. The April final judgment order made substantive rulings and adjudicated disputed rights based on motions filed by the parties, including fraudulent inducement and quitclaim versus warranty deed, a decision which impacted the Hills' capital gains tax liabilities. Thompson v. Graham, the only case cited by Mr. Boren on this issue, is currently awaiting appeal to the Tennessee Supreme Court after permission was granted by that body. Even so, there were no other issues to adjudicate in Thompson and no motions were pending. Instead, a notice of appeal was filed. Therefore, it is distinguishable from the instant case. Materiality is a question of law and is not measured by the dollar amount alone. The issue of property taxes was explicitly included in Ms. Hill's September 23, 2024 written offer. The agreement was contingent on whether the documents accurately reflected the understanding of the parties. Mr. Boren, after remaining silent on the issue during negotiations, included the issues of property taxes and warranty deeds in his initial settlement documents. Ms. Hill immediately notified the trial court of the disagreement and lack of consent and objected to Mr. Boren's changes when she discovered his true intent, asking the court to enforce the agreement as she understood it. Mr. Boren cites the Rainey case on silence to argue that silence on a term is rejection. However, this unreported case does not contain the word silence at all. In fact, the counteroffer of $50,000 directly addressed the offer of $25,000, after which negotiations ceased. Ms. Hill cited Smith v. Smith, which addresses silence and reveals that silence is an indication of acceptance, not rejection. Mr. Boren remained silent on the property tax issue while addressing only the number of lots in his counteroffers to Ms. Hill. Indeed, in the final documents created by his counsel, Mr. Boren included every item contained in Ms. Hill's original offer, except his responsibility for the property taxes. That makes it material. Fraud in the inducement. All the required elements are present. Under Smith, Mr. Boren's silence is a false representation that deliberately misled Ms. Hill. It was made knowing and intentionally. Mr. Bourne's argument shows that he had no duty to advise Ms. Hill of his position regarding property taxes, illustrates that his silence was knowing and intentional. Reasonable reliance. Mr. Bourne's documents contained all Ms. Hill's original provisions except property taxes. He shifted 100% of that responsibility to the Hills. Ms. Hill had no reason to expect this change based on Mr. Bourne's previous silence. Damages. Mr. Bourne's request that Ms. Hill notified the court before he sent the documents was a contrivance used against Ms. Hill when she discovered the discrepancies advanced by Boren. In addition, Ms. Hill paid the entire 2024 property taxes. Boren now attempts to trick this court by stating he offered to pay 100% of the property taxes, but he left out his clarifying language. He would agree only if the court ordered him to do so. Consent judgment and contract enforcement. Labels do not control. When enforcement depends on consent, and consent is withdrawn before entry of an order, Harbor v. Brown prohibits judicial enforcement by decree. In this case, the trial court added terms, threatened Ms. Hill with contempt, and ordered execution of the deeds over the Hill's objection. Essentially, the trial court turned the proceeding into a coerced judgment, regardless of nomenclature. Missing terms and reasonableness. There's a critical difference between supplying a missing term and rewriting a disputed term. All the cases cited by Mr. Boren involve situations where a settlement agreement was reached, but a term was left blank or undefined, allowing the court to fill the gap. This was not a gap. Ms. Hill's position was that Boren pays property taxes. Mr. Boren's position was that the Hills pay the property taxes, though this new condition was added after Ms. Hill thought a settlement had been reached. The trial court inserted its own term, but where parties have materially different understandings, there's no contract to enforce, even if the trial court believes its solution is reasonable. This has been the law in Tennessee, according to our Supreme Court, since 1962 in Johnson v. Central National Insurance. Summary judgment is also appropriate on Mr. Boren's claims against Ms. Hill. He waited 32 months after the law offices of T. Robert Hill, P.C., with Ms. Hill as an employee, began occupying the partnership property. Under Lease v. Tipton, Mr. Boren's claim does not relate back under TRC 15 because it fails under the second prong of the rule. Mr. Boren did not make, and did not claim that he made, a mistake or misnomer concerning Ms. Hill's identity. Statute of limitations in partnership context was 1 year. The specific statute overrides the more general 3-year limit found at 28.3105. Mr. Boren is keenly aware of this policy that specific trumps general, based on this court's decision regarding Mr. Boren and Mr. Boyd's attempt to take Mr. Hill's IRA. Conversely, Cagle v. Hyber, cited by Mr. Boren, does not address partnership duties. Therefore, the statute of limitations bars his claims against Ms. Hill, just as pled in her initial answer, along with laches. As early as January 2020, the trial court correctly observed that Mr. Boren had no standing to bring claims against Ms. Hill on behalf of the partnership. Partnership property, including any rent to the partnership, is not the property of the partners individually. 61.1203 and 501. Mr. Boren tries to circumvent this claim by claiming vicarious liability, but that is a theory of liability. It doesn't create standing where it doesn't exist in the first place. In addition, the Tennessee Supreme Court in Benz v. Trader Joe's clarifies that vicarious liability is the legal rationale for holding a master responsible for the tort of a servant. That is not the fact pattern in this case. Ms. Hill did not owe Boren or Hill-Boren Properties the duty to pay rent. To hold otherwise would create a new and unprecedented liability for employees whose employers occupy leased premises. Ms. Hill was an employee, not a partner in the partnership, not a stockholder in the law firm, nor a party to the lease agreement. If rent was owed, which is disputed, it was owed by the law firm, not Ms. Hill. The fact that Ms. Hill is Mr. Hill's wife does not create a duty by Ms. Hill to pay rent. Ms. Hill is an independent individual, not an extension of her spouse. Married women have been emancipated for over 100 years. Mr. Boren claimed in his litigation against Mr. Hill that Ms. Hill was given virtually free place to practice in the Hill-Boren Properties building as a result of the AFT between himself and Mr. Hill. And the fact that she did stay in that building was evidence that Mr. Boren had complied with the AFT. The Tennessee Supreme Court in Garland, and also in Pewis, Market, and Stearns Coal and Lumber, all dictate that these statements notifying the court of a client's position are binding on the client. Weber, which was cited by Boren, reinforces that Mr. Boren is bound by this prior inconsistent position. TrawMed explains the intercorporate conspiracy immunity doctrine, a doctrine embodied by the facts of this case. Mr. and Ms. Hill were both employees of the PC. The allegation was that the PC failed to pay rent to the partnership. Ms. Hill's employment was open and obvious, occupying the property as an employee, not as Mr. Hill's wife. Rent is directly related to business operation, and Ms. Hill had no independent business relationship with the partnership. The fact that an employee, or even their spouse, benefits from the success of any employer does not convert that beneficial relationship into a conspiracy. Under Kincaid, at least 2 people are required. It is undisputed that Ms. Hill was an employee of the firm, and Boren made no allegation that Ms. Hill acted outside her scope of employment. Therefore, Ms. Hill is legally indistinguishable from her employer for conspiracy purposes. Without a duty to pay rent, there cannot be a breach, and given Mr. Boren's admissions, she had no duty to pay rent at all under Logue v. Fisher. Finally, Mr. Boren has asked for damages under 27-122. This request is baseless because substantial legal issues are raised by this appeal. Enforcement when there's no agreement, after withdrawal of consent, and in the presence of fraudulent inducement, statute of limitations, and intercorporate immunity. This appeal was timely and is not frivolous as that the term is defined. It was brought because the trial court forced acquiescence to terms that were never agreed to by all the parties. The trial court threatened Ms. Hill with sanctions to enforce the agreement it created. Ms. Hill is entitled to summary judgment on Mr. Boren's claims. The trial court's rewriting of the parties' attempted agreement is not allowed under Tennessee law. This case should be remanded for trial by jury between Mr. Hill and Mr. Boren. Ms. Hill should be granted summary judgment and/or dismissal of all claims made by Mr. Boren against her, as the statute of limitations ran before he filed his claim. His claim does not relate back because there's no mistake or misnomer. Ms. Hill cannot conspire with her employer, and Ms. Hill owed Mr. Boren no duty at all. I'm finished.
Okay. You want him to finish out the initial time?
I'm sorry?
You want him to finish out?
Yes, Your Honor.
Okay. And, okay. Now, you're going to come back on rebuttal, or is,
It may just depend on what they say. We may not have anything to say at all.
okay. How much time does he have left?
2:14.
You got
How much?
2 minutes and
14
14 seconds.
seconds.
Sorry.
That's okay. I hadn't intended to readdress everything Ms. Hill talked about anyway. The one thing that I do want to address is the summary judgment that this trial judge actually granted that brought any settlement discussions to the thing, and it reminded me of a conversation I once had about leverage. Leverage changes during a lawsuit. Summary judgment changes leverage probably as much as anything in our procedure book. On this particular one, Mr. Boren and Mr. Boyd went out and formed a competing property ownership partnership on the second day of December, right across from the courthouse, like they were going to just start up their new business. And this was while Hillborn Properties still existed, had not been dissolved, still has not been dissolved, and he was competing because he planned to walk off with, not carry out the ATA, but walk off with it and start his own law practice. Happens a lot, but in this particular instance, it's not a summary judgment issue because, Your Honor, Your Honors, there's many factors that went into that, including the fact that 4 days after he bought the building and started B&B Properties, which is a real estate ownership company, where Mr. Boren and Mr. Boyd are partners, 4 days later, they filed a $16 million lawsuit against me and against Hillborn PC. And the big issue is Mr. Boren wants to conflate the acts of a stockholder who can prepare to compete, even if they're a stockholder, to those of a actual material partner in a partnership. And in this partnership, we were about ready to make some steps to close everything down, and Mr. Boren goes out, buys a building. He and Mr. Boyd form a partnership to compete with Hillborn Partnership, buy a building for their law office. They're in it right now. They were in it within 20 days after they did it. And frankly, there isn't a whole lot of fiduciary responsibility upon a partner, but he was a 32% partner in this. I was a 68 partner in Hillborn Properties, and he goes out and starts a competing business. with the intent of taking Hillborn PC, the only tenant Hillborn Properties ever had in that building for 35 years. And he bought a building in order to take Hillborn PC out of Hillborn Properties assets.
Thank you, sir.
That's all I have.
Okay.
Any questions? Thank you.
If it please the court, my name is Teresa Luna, and I'm here on behalf of Ricky Boren today.
Okay.
At the outset, this court must decide and resolve the subject matter jurisdiction issue. It's a threshold inquiry that must come first before the other issues are determined. Rule 4A of the Tennessee Rules of Appellate Procedure require a notice of appeal to be filed within 30 days of the entry of the final judgment. There's also a case, Thompson v. Graham. It's a 2025 Court of Appeals case that tells us if the notice of appeal is untimely, the appellate court lacks subject matter jurisdiction. I'd like to dive into two cases, if I may, on the subject matter jurisdiction issue, because I think they'll be very helpful to the court in resolving the subject matter jurisdiction issue. The first one is, of course, Thompson v. Graham. In that case, it was a business dispute between business partners, much like in this case, and the partners entered into a settlement agreement. The court entered a final judgment and found that there was an enforceable settlement agreement. Then afterwards, there had to be some help from the court to get the parties to the finish line. So the two rulings from the Thompson case are important. The first one, this is the most important one. When consecutive final judgments are entered, a later judgment is considered the final judgment only if it affects the substantive rights settled by the first judgment. In other words, if the court enters a final judgment and then it issues some additional final orders that it declares are final and can be appealed, that first judgment is still the final judgment unless there was some substantive right that was altered by one of the later judgments. That case is important, but it still leaves some blanks, and I think the court would need some help on, and that's where the Allen versus American Yeast case comes into play. That was a car wreck case. Ms. Allen was in a car wreck with an employee of American Yeast. She had some brain injury, and so she appointed her mother as her POA for the purpose of the case. The mother went into settlement negotiations, settled the case, and entered into a settlement agreement. Right soon after, Ms. Allen revoked the POA and said, no, I'm not signing any of the settlement documents and the releases. So we got in the Allen case exactly what we have here. We have a final order that's entered, and then we have some subsequent orders that come along that help, again, get the case to the finish line that have to do with the settlement. In the Allen case, it was where should the money be interpleaded, and also is there civil contempt for refusing to sign the settlement agreement. So that brings us to our case, and those are instructive in our case. And here are the facts that are important here. November the 1st, 2024, the court entered its order enforcing this settlement agreement between the parties. It looked at the email chains and found that there was an enforceable agreement. It also found that there was a missing term that had to do with property taxes, and that the court should fill in the blank on that missing term, and found that the parties should each pay their pro rata share of the property taxes, because that's the usual course of business for real estate parties. So that left 4 issues to be finished up by the court before the final judgment could be entered. Those issues were the dissolution of the partnership, how the charging order from the underlying case should apply, the business expenses that had to be paid for the maintenance of the building, and also the distribution of the funds that the court was holding. So fast forward to March 20th of 2025, the court enters orders on all 4 of those issues on March 20th while we were in court. And then right afterwards, also while we were in court, the court entered a final judgment in the case, finding that all the matters in the case had been resolved, making March the 20th the date of the final judgment. There are, just like in the Allen case and just like in the Thompson case, there are some orders that come after the final judgment. And the orders that come after the final judgment in this case do not change the rights, the substantive rights that were dealt with in the final order from March the 20th. The first one was April the 2nd, and it was just correcting a clerical order in the clerical mistake in the order. The next one was April the 10th of 2025, and the Hills were refusing to sign the quitclaim deeds and refusing to sign the settlement agreement to get the case to the finish line, and the court entered an order ordering the Hills to sign the settlement agreement and to execute the deeds. The Hills did not do that according to the court's wishes, and so Boren files another motion, and we end up in court in June of 2025, and that's the last order in the case. June 20th, 2025, the court entered an order on Boren's motion for the court to execute the quitclaim deed and his motion for contempt. The court did not find contempt, but it did do something that I think is important here. In the June 20th order, the court said, I'm reversing myself from the April 10th order. Again, the April 10th order comes after the final judgment. And he said, I am not ordering the Hills anymore to sign the quitclaim deed or to execute a formal settlement agreement. He said, I found that back in November that there was a settlement agreement that's enforceable, the emails. And now I'm asking the clerk of the court to execute the quitclaim deed and end this case. So here's what we've got. We've got the Hills appealing the case on May the 8th, 49 days after the final judgment was entered. Now, again, after the final judgment was entered, March 20th, you've got two subsequent orders, but all they are doing is just handling administrative tasks, getting the case to the settlement finish line, so to speak. And both Thompson and Allen cases tell us that administrative tasks, getting a settlement agreement to the finish line, does not alter the final judgment date. So that's where we are. I think the next step is, so what exactly did the Hills appeal, right? And is anything that the Hills appeal, in their appeal, is it from one of those later orders? Because the 30-day window includes the April the 10th order of the court and the June 20th order of the court, those two orders. They could appeal those two orders, in our opinion. That's within the subject matter jurisdiction. Here's the key thing to take away. Nothing in the April the 10th order or the June 20th order has been appealed by the Hills. Everything they're appealing comes from the final judgment that was entered on March the 20th of 2025. And so for that reason, you know, our argument is that there is no subject matter jurisdiction by this court over anything that the Hills have appealed in this case. But I would like to briefly address some of the issues that if this court were to find that it has subject matter jurisdiction, I'd like to address some of the issues that the Hills appealed, particularly with regard to the enforceability of the contract. And fortunately, the court can see every single one of the settlement negotiations between the parties. They are documented in emails. It all happened through emails. And you can see what occurred there. The Hills say there's no enforceable contract because Boren refused to pay the entire year's worth of property taxes. Here's what I'd like the court to look at really closely. The first offer by the Hills was September the 23rd of 2024. That offer was, we will offer some property in Gibson County in settlement of the case with Boren paying the property taxes for the entire year. Boren came back 2 days later and rejected that offer in its entirety and made a completely different offer. Okay, that's where Brainy versus Medical Specialty Clinic tells us a counteroffer is a rejection of an offer and puts that original offer to bed. It's no longer on the table anymore. What I'd also like the court to look at is that not one single one of the negotiations after the Hills first offer, September the 23rd, not one single one of those counter offers back and forth contained anything about property taxes at all. And when you get to the final email that the parties all agree on, nothing is said about property taxes. So the Hills, we have trouble getting a settlement agreement and deeds done after this agreement is entered. And so the Hills file a motion to enforce the settlement agreement. And they say that Ricky Boren should pay the property taxes. We come before the court. Ricky Boren agrees in his response, yes, this should be enforced. He wants this agreement to be enforced. The court ruled that it was the emails were an enforceable settlement agreement, and that the key material terms were there. There was an offer and acceptance, and that that it makes an enforceable agreement. The only thing the court found was that there was a missing term, but it was de minimis. It was having to do with the property taxes. And you will see that the court held that under Dick Broad versus Oak Ridge Farms, the court held that reasonable terms can be implied into a contract if a missing term is at issue. That's what happened. There was a missing term, and the court entered and said the parties will pay pro rata share of the property taxes for that particular year, because that's a usual course of business between parties to a real estate contract. Next, the Hills argued that there was a consent judgment and they repudiated it. Well, I would ask the court to look at all of the facts there. There's no consent judgment in this case. There was an enforceable contract that the parties came before the court, and both parties asked for the court to enforce it. But there was no consent judgment. But even if there were, there's a case that's very helpful here. It's McMahon versus McMahon. McMahon versus McMahon says, even if there's a consent judgment and the party repudiates the consent judgment, there still remains the issue of whether the contract should be enforced. And that's what we have here. Even if you find there's a consent judgment, which I don't think you will, but even if you do, should the contract have been enforced by the court? And we believe that it should. The Hills also argue that there was fraud in the inducement, and their argument is based on what they say is Mr. Boren's silence after the initial September the 23rd offer. Their offer included property taxes. None of the later counter offers included anything about property taxes, and they say that Mr. Boren, his silence misled them, and that was fraud in the inducement to get them to enter into that contract. Here's the case that's helpful. B&R Construction versus Tennessee Investment Properties, 1990 Tennessee Court of Appeals case. That case tells us there must be something more than mere silence. There must be an active concealment, making use of some device to mislead. I think you will find that there is nothing of that character in any of the emails between the parties in the settlement negotiations. This court will see in the pleadings that several times Mr. Boren filed pleadings with the court. This is after the contract was enforced by the court, saying that I'll pay the pro rata, share of the property taxes. I will agree to quitclaim deeds instead of warranty deeds, another issue that the Hills had brought up. Even later on, Boren said, I will pay the whole year of property taxes and agree to the quitclaim deeds. Everything that the Hills were arguing about, Boren said, I'll do that if we can just get this case over with and avoid an appeal. And the Hills refused that to the very end, and we're here today on those issues. So because of that reason, and because there are no appealable issues that this court has subject matter jurisdiction over, Boren would ask that the court grant his attorney's fees and his costs and his expenses under Tennessee Code Annotated 27-1-122. The Hills mentioned their summary judgment rulings that they are complaining of. I will bring up about Mrs. Hill's, particularly in the time I have left, that Mrs. Hill violates Rule 6 of the Tennessee Rules of Appellate Procedure because she does not say what order she's appealing from. There are 3 summary judgment orders. She doesn't cite to it in the record. She doesn't cite to the facts. She doesn't say where the court was wrong in those summary judgment rulings, and that is a clear violation of Rule 6. And if you will notice in the 2023 Boren versus Hill-Boren case, that this court cited Mrs. Hill under Rule 6 for the very same thing. Mr. Hill's summary judgment ruling, we believe it should be upheld, and we have spent a great deal of time in our brief explaining why the court was right about that ruling. And if there's no other questions, I appreciate the court's time and would respectfully request that the court uphold the trial court's ruling.
Okay, I hear no questions. Thank you very much. Yes, ma'am.
Thank you, Your Honor. Just a couple of things to clarify. The order on March 20th that they keep saying was final was not designated as a final order. The property tax provision was not missing. The counteroffer didn't mention it one way or the other. It didn't say, I reject this. It said, give me 5 lots. Give me 6 lots instead of 3. Give me 5 lots instead of 3. The only thing that Mr. Boren and Ms. Hill ever went back and forth about was the number of lots. Everything else in that agreement relates to Mr. Boren and Mr. Hill. And Ms. Hill and Mr. Hill are not the same person. Ms. Hill has rights separate and apart from Mr. Hill. The Hills did sign a quitclaim deed and a settlement agreement that had clarifying language that said that it was being signed under threat of contempt and subject to appeal. But that was not acceptable to Mr. Boren, so the court ordered the clerk to do it. And so telling you that we didn't sign one is not an accurate statement. Like I said, the counteroffer was only regarding lots. It didn't address property taxes. Johnson versus Central National Insurance, I think I mentioned that to the court before. If it's in there, the court can't make something different. So it was in there that he was supposed to pay 100%. He says nothing. We think we have a settlement. They send paperwork back that says the Hills are going to pay 100% of the property taxes. Well, there's no way that that's not material when both parties are insisting that the other pay 100% of the property taxes. B&R, and I forgot to mention that, also says if there's a trick or contrivance. The trick was silence. The contrivance was, you tell the court we've got it settled. Thinking that we did, I sent the email. Ms. Hill sent the email. Then Ms. Hill got the settlement documents that did not reflect what the emails said. The bottom line is, if they had agreed to pay 100% of the property taxes and agreed on the quitclaim deeds and done the settlement exactly the way the emails said we were going to do the settlement, we wouldn't be here. We are here because a court took sides and inserted a term that contradicted what both parties said. We said 100% to him, he said 100% to us. The court said, let's split the baby. Johnson versus Central National says, doesn't matter how reasonable it is, you can't insert another term. If it's missing, yes, you can put it in. But where it's there, you can't just change it. So that's why we're here.
Thank you all. I'm going to thank the parties for their argument. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you again, both. These parties may be excused.